Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, for those of you who've been geeking out here on this channel for a while now, you know that the ATF has given us lots of material to work with, and I do want to thank the good folks at the ATF for that. But whether it's been solvent traps, suppressors, Form 1s, short-barreled rifles, AR pistols, the ATF has gone completely bonkers in the last few months, and one would seem they possibly could not have any more manpower or energy to go after anything else. But think again, because here they come this time after your forced reset trigger. So we're going to spend a few minutes talking about a very important letter, because here comes the ATF after your forced reset trigger. Okay, before we get rolling, you guys know the drill. If you like this video, go ahead and click that like button. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button. Click the little bell logo if you want to be notified when we post new videos. And most importantly, let's keep the comments and discussions coming. That's how we're going to make sure that we're getting our videos out to more lawful and responsible gun owners like yourself. Okay, just so you know, we got a couple of other videos coming out that relate to a whole set of new rules that the ATF is drafting to redefine frame and receiver, therefore redefine firearms, and therefore expand the scope of federal law to bring more firearms, firearm components, and activities under the purview of that law. Well, in keeping with that tradition right now, well, the ATF has something else as it relates to forced reset triggers. Now, we've done some videos already on the forced reset trigger, both as it relates to Washington state law and as it relates to federal law and as it relates to some recent ATF efforts, because we kind of predicted that this was coming. Well, an open letter was sent this week to all FFLs by the ATF about forced reset triggers, and I want you to pay particular attention to the language of this letter, because you can see where this is going. Now, the letter from the ATF to all the FFLs started out as: the Bureau of Alcohol, Tobacco, Firearms, and Explosives recently examined devices commonly known as forced reset triggers, FRTs, and has determined that some of them are firearms and machine guns as defined in the National Firearms Act, and machine guns as defined in the Gun Control Act. So the ATF right off the bat is saying, hey, listen, some of these we are defining as machine guns. Which ones are they? Well, they go on to explain that these particular FRTs are being marketed as replacement triggers for AR-type firearms. Unlike traditional triggers and binary triggers, sometimes generally referred to as FRTs, the subject FRTs do not require shooters to pull and then subsequently release the trigger to fire a second shot. Instead, these FRTs utilize the firing cycle to eliminate the need for the shooter to release the trigger before a second shot is fired. By contrast, some aftermarket triggers have similar components but also incorporate a disconnector or similar feature to ensure that the trigger must be released before a second shot may be fired and may not be machine guns. So as you can see, the FRTs that are not requiring the trigger to be pressed each time, and I know that that's debatable because the way it works, the trigger is technically being pressed each time, but if there is not some type of a disconnector to this device, in all likelihood, the ATF is going to be defining that now as, in and of itself, a machine gun. Now, the ATF justifies this by stating the following: both the NFA and the Gun Control Act regulate machine guns. Machine gun is defined under 26 U.S.C. Section 5845B and 18 U.S.C. Section 921A23 as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include firearm or receiver or any such weapon, and this is the rub here, and any part designed or intended solely and exclusively or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts which a machine gun can be assembled if such parts are in the possession or under the control of a person. And you can see that that's the last section that they're catching up on. But then the letter goes on and states more. ATF's examination found that some FRT devices allow a firearm to automatically expel more than one shot with a single continuous pull of the trigger. For this reason, ATF has concluded that FRTs that function in this way are a combination of parts designed and intended for use in converting a weapon into a machine gun, and hence, ATF has classified these devices as machine gun as defined by the National Firearm Act and the Gun Control Act. So, there you are put on notice. Right now the FFLs are being put on notice, but I have a feeling that all of you are going to be put on notice that if you bought a trigger with this type of configuration to it, that now is being defined as a firearm in of itself. It's being defined as an NFA regulated firearm known as a machine gun, and you're in unlawful possession of it. The letter further states, accordingly, ATF's position is that any FRT that allows a firearm to automatically expel more than one shot with a single continuous pull of the trigger is a machine gun and is accordingly subject to the Gun Control Act prohibitions regarding the possession, transfer, and transport of machine guns under 18 U.S.C. Section 922(o) and 922(a)(4). They are also subject to registration, transfer, taxation, and possession restrictions under the National Firearms Act. The letter then further states, under 26 U.S.C. Section 5871, any person who violates or fails to comply with the provisions of the NFA may be fined up to $10,000 per violation and is subject to imprisonment for a term of up to 10 years. Further, pursuant to 26 U.S.C. Section 5872, any machine gun possessed or transferred in violation of the National Firearm Act is subject to seizure and forfeiture. Check this out then. Under 18 U.S.C. Section 924, any person who violates Section 922 subsection O may be sent to prison for up to 10 years and fined up to $250,000 per person or $500,000 per organization. And if there is any doubt that the ATF is coming after these triggers, then check out the language in this next paragraph. Based on ATF's determination that FRTs that function as described above are machine guns under the National Firearm Act and the Gun Control Act, ATF intends to take appropriate remedial action with respect to sellers and possessors of these devices. Current possessors of these devices are encouraged to contact ATF for further guidance on how they might divest possession. And divest possession is a kind way of saying surrender your property. The letter concludes, if you are uncertain whether the device you possess as a machine gun is defined by the Gun Control Act and the National Firearms Act, please contact your local ATF field office. You may consult with the local ATF's office webpage for office contact information. And the letter is signed by Alfonso Hughes, Assistant Director of the Enforcement Programs and Services, and George Lauder, Assistant Director of Field Operations. Well, what does this mean? Well, it means that right now the Full Employment Act for ATF agents is live and well because they will have plenty to keep them busy this summer. But they specifically said they are taking proper enforcement and remedial actions. What's that mean? Well, they sent the letters to the FFLs first, and you know they're going to go to the FFLs, and they're going to see how much of that inventory is there. They're going to seize it, and they're going to seize all the sales records for anyone else who purchased these. If you have one of these FRTs, one of these force reset triggers that falls under this classification, yes, it is my opinion that the ATF will be coming for that trigger. Now, listen, should you be contacting the ATF right now on your own? No, you should never be contacting the ATF on your own. Why? Well, they are a little bit of the gotcha department. They are certainly not on your side. They are certainly not on the side of lawful and responsible gun owners who purchased otherwise legal products and now are being told that these products are illegal. I encourage all of you to contact skilled and experienced local counsel in your jurisdiction so that they can have communications with the ATF if they believe that that is appropriate. I'm sure there will be a lot more developments happening, and as we learn of them, we will keep you posted here. Listen, in the meantime, you may have more questions about this or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.